So you're charged with terroristic threat. You are facing.
And here's where things heat up instantly. A terroristic threat charge isn't just courtroom flair. It's one of those offenses where the words alone can land you in jail if the victim genuinely feared for their life. When the judge opens with a 6-month jail possibility, that's her signaling this is not a minor misunderstanding. Quick question. Do you think threatening language should carry criminal weight even when no weapon is found?
Up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. So, okay.
On March 7th, 2025 in Harris County, Texas at 315 Capitol Street in Houston, Texas. The complainant is a security guard for the building and was walking around Bagby when he found the defendant sleeping on the sidewalk. The defendant was not supposed to be there, and the complainant told him repeatedly that the defendant was not allowed to be there until around 11 p.m. at night. The defendant then began to get hostile and aggressive and threatened to shoot the complainant while slowly reaching into his bag. The complainant feared for his life.
Did you say he's not allowed to be there?
This right here is the heart of probable cause. The complainant says the defendant reached into his bag while making a gun threat. Even without seeing a weapon, that combination, verbal threat, reaching gesture, is often enough for courts to greenlight charges. Notice how the judge instantly zooms in on inconsistencies about trespass timing. She's testing the strength of the whole narrative.
Until 11 p.m.? Did I hear you say that? What is it?
I don't know. When the complainant, we did not charge a trespass in this case. So when the complainant said you're not allowed to be there, we leave back at 11, and that's when the responded.
What did he say again?
Complainant repeatedly told the defendant that he was not allowed to stay there until after 11 p.m. to 7 a.m. And since it was before 11 p.m., he was there for trespassing and not allowed to be on the premises. The defendant had threatened the complainant that he was going to get his gun and shoot him by signaling this might go in his bag with his plant field first.
He said, I'm going to get my gun and shoot you?
Classic legal moment. The defendant tries to explain himself, but the judge shuts it down. Why? Because anything he says, even innocent details, could accidentally strengthen the prosecution's case. This is the judge protecting him from himself. Viewers, do you think courts should let defendants speak freely? Or is this protective silence the smarter move?
I don't have it opposed by saying the defendant threatened the complainant that he was going to get his gun and shoot him, signaling this by going to his bag.
Ask a question.
Who wrote the report? The actual officer who got threatened or someone else?
The officer did not write the report. I mean, the officer wrote the report, not the security guard. The security guard was the one who was threatened.
Mr. Robinson, I'm going to find probable cause for now. Okay. Let me give you a lawyer. Talk to the lawyer. Just don't have any contact with the security guard. That's the only thing I'm going to ask you to do. Right?
If I might say real quick, I know you're busy. They have a city ordinance. That's why you can't lay at 11. But I was recently jumped. I got my medical records.
Look, don't tell me because I've got a bunch of DAs. I don't want you to say something that hurts the case. Let me give you a lawyer. Everything you say, when you want to tell me, tell the lawyer, and then they can tell me what.
I understand.
Okay.
Speaking of the defendant works this location, and we're not asking for contact with this location.
What is this? What is this place?
It's in the hospital building downtown.
That's the top. That's where I was at.
Don't go back, please. The problem is I don't want you to run into the security officer. Then more bad blood comes up. They file more charges. That's why.
I understand. I never said that ain't true. I'm already filed a motion for discovery inspection. So I need to have a bag on me.
Don't worry about it. We'll take care of you. I'll have you sign a reset Victoria. We'll have you take a seat. Let me find your lawyer.
Yes, sir.
Okay, please.
Right this way.
If you can file this, please, the condition. No going back. Sorry?
Whenever you're ready to sign.
Yeah. I thought I signed it. Yeah, I signed it already.
You didn't know just now.
Yeah, so we can get them out. Mr. Lechuga, come up. We'll have you sign your condition. We'll get you out. You, Jessica Ariza, come on up. Ariza, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Okay.
Okay.
On March 9th, 2025, in Harris County, Texas, officers were dispatched to a suspicious person call. Officer met with the witness who stated that the defendant was looking for her children and was at a nearby residence. The officer then made contact with the complainant at the residence, who stated the defendant had been intoxicated at a family gathering earlier, and they began to argue at home before the defendant assaulted the complainant. The defendant admitted to striking the complainant with the television. The officer noted the complainant to be bleeding from his face. The complainant is her ex-husband.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of any weapons. Do you see a protective order that has been issued? in this?
It needs to be, outside.
Okay, ma'am, I'm issuing now what's called a magistrate's order for emergency protection that identifies Mr. Roberto Baron as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes.
If you violate this court order, the state can and probably will file a violation of protective order. That is one of the worst cases you can pick up. Just don't have any contact. Don't use alcohol, any dope. You'll be fine.
Okay.
Just, I'm going to protect my city at all costs. And if that means putting you in, I'm going to do it in a heartbeat.
Okay.
Now, do you have the ability to hire a lawyer, ma'am?
No.
Do you work?
Yes.
Okay, you work full-time?
Yes.
Okay, I'll have you fill out an application. Do you have any children?
I have 3.
Okay, I'll have you fill out an application. Let me take a look at it to see whether you qualify and then we'll talk.
Okay.
Do not leave until you sign our bond conditions though. Don't worry, because since she'll be monitored for no alcohol, we'll have Felicia do it. Okay, please. Deputy Miranda will give you an application. All right, good morning, Mr. Lechuga. Good morning. So you're charged with displaying a fictional license, is a plate, right?
That's it?
You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7th, 2025, at approximately 6:32 a.m., an officer observed a vehicle with expired registration as of June 2021. A traffic stop was initiated. The officer ran the license plate and it returned to a different vehicle. The officer made contact with the defendant, the sole occupant, and the defendant stated he purchased the vehicle 7 months ago and had not been able to register the vehicle due to long work hours. The defendant was detained and the defendant stated he had already received a citation for displaying a fictitious license plate by the LaPorte Police Department in January of this year.
Okay. Can you run his license, please? Does he have a license? Mr. Lechuga, I'm going to find that there's sufficient probable cause to go forward with your case. I am placing conditions on your bond now that you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, car insurance. God forbid you get into an accident and you maim someone and they come after you and sue you for $50,000. You got to hire a lawyer. You'll never crawl out of that hole. That's why you get car insurance, because they're not on purpose, or accidents for a reason. When you have insurance, they represent you. They'll get a lawyer for you. That's why you need it. If you don't have it, don't drive. Do you understand?
His driver's license is eligible.
Okay. So as long as you have those two, you may continue to drive. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Casanova Mission. They'll tell you if and when you have to come back to court. She tells you that you pick up a new case, you start acting a fool in the free world, I will take it away from you. All right, I'll have you sign a resale with Victoria and then we'll get you out of here. Thank you.
No driving affidavit?
You were on bond for an assault case that have taken off on us at least 3 different times, and now you've picked up a new case. You were charged with failure to identify oneself while being a fugitive from justice. On that case, you're now facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 7, 2025, at approximately 4:44 p.m., an officer observed a vehicle with expired registration as of December 2024. A traffic stop was initiated. The officer made contact with the defendant, the driver, advised he did not have any form of ID on his person, and provided his name as Daniel Escamilla, date of birth, April 24th, 1998. The officer did a search and saw the defendant did not resemble the Texas driver's license that came up for Daniel Escamilla. The officer got a hit for David Escamilla, the defendant's real name, and saw there was an outstanding warrant. The Texas driver's license photo for David Escamilla resembled the defendant. The officer utilized mobile APIS and confirmed that the defendant was David Escamilla. The defendant admitted to providing the officer with his twin brother's information instead of his own due to the open warrant.
Do you see if he has a license? Can you check, please?
Yeah, it's ineligible, Judge.
Okay, Mr. Escamilla, I'm going to have you sign an affidavit with me today. I don't give a rat's behind what is going on in your life. If you don't have a Texas driver license and liability insurance, you are not to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Yes, sir.
You have a lawyer, Mr. Escamilla.
No, sir.
I'm going to appoint you a lawyer today. Your assault case is 1,000 days old. We are going to figure out what happens with this case today. Can you appoint him a lawyer, please? If this case gets reset today, you will get an ankle monitor, and I'm going to send you for a drug test right now. I want to ensure that you're not using anything as well. You know what? Let's just do that now. Felicia, if you can send in, please. If you fail to take the test, if you fail to come back, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, sir.
The next time you take off on me and fail to come to court, so help me on those bonds. Do you understand?
Yes.
Take a seat for me. Joseph Martin?
Yes, sir.
So, Mr. Martin, you have a total of 4 open cases. You're charged with 4 counts of assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 8, 2025, officers were dispatched to 4527 Perry Street in Houston, Texas, in Harris County regarding an assault. The complainant, Hayes, stated that she was in a verbal argument with the defendant, and that led to her being pushed by the defendant. Complainant Hayes said that she hurt her hand due to being pushed into a car with the defendant and that she felt pain. The complainant, McDaniel, then stated that she confronted the defendant to see if her friend getting assaulted by the defendant. The defendant then started swinging and struck the back of Daniel's head, and that complainant felt pain as well. Complainant Powell then stated that she was assaulted by the defendant due to also trying to defend her friend, complainant Hayes. Complainant Powell says that he approached them to confront the defendant, and the defendant just started swinging and that she got struck by the defendant. Complainant Powell stated that she was not recall how that she was hit, but that she felt pain. Complainant Martin stated that she knows the defendant from school and they both attend TSU. The complainant Martin stated that she was trying to calm the defendant down but does not remember the physical assault due to her being knocked out unconscious by the defendant. Complainant Martin felt pain. A witness stated that she saw the whole incident and saw that the defendant was arguing with complainant Hayes and that the defendant started pushing complainant Hayes into a vehicle. Complainant Martin was then trying to de-escalate the situation and stated that when she saw complainant Martin get struck by the defendant and get knocked unconscious for approximately 2 minutes.
Is that number 3 or 2?
That's 4.
That's the 4th.
That's 4th, Your Honor. The witness then stated that she saw the defendant punch complainant Martin on the left side of the face. The defendant admitted to being involved in the physical altercation with the complainant and pushing them away. The complainant 2 had a knot on the back of her head. Complainant 3 had a small swelling on the left side of her face. And complainant 4 had small swelling under her left eye and was transported to the hospital due to being unconscious.
All this happens at TSU?
It is. It was a party, yes, Your Honor.
Mr. Martin, I'm going to find that there's probable cause to go forward with your case. I'm now barring you from going to TSU.
Yes, sir.
I'm barring you now from going to TSU.
Oh,
I'm also ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in this case, not to consume alcohol, illegal drugs, not to be in possession of weapons. If I find that you're a danger to my community, I will do everything in my power to take you off the street. Do you understand?
sir, I understand. May I ask what, this bar? Okay.
You have the ability to hire a lawyer, Mr. Martin.
No, sir.
You work.
Sir.
I'll have you fill out an application. Deputy Miranda will give you an application. I'll see whether you qualify for an appointed lawyer. I'm going to have you sign a receipt with Victoria, then I'll have you meet with Felicia for your bond conditions. Life is way too short to sit in a box that's 6 by 9, man. Keep my city safe. Otherwise, it's going to go sideways real quick. You understand?
Yes, sir, I understand.
Okay, come on.
Thank you.